Hello again, everybody. This is attorney Mark Brunner. Thank you so much for joining me here today, again on Talking Texas Law. Well, today let's talk about a topic that has unfortunately been brought up in the news here recently here in Texas, and that is the issue of what's called no-knock warrants. Here recently, the date of this video is late February of 2019, and almost 1 month ago on January 28th, down in Harris County, Houston, Texas, HPD, Harris County Police Department, or Houston Police Department officers served a no-knock warrant on a house, alleging that there had been a drug buy there. A confidential informant had entered the house, purchased a large amount of drugs, came back, cooperated with authorities, told them about his drug buy at this house. Based on that information, the lead detective obtained a warrant that authorized what's called a no-knock warrant. So not having to announce your presence. The officers, based on that no-knock warrant, made entry into that house there in Houston. There was a shootout. The couple who owned the house, their dog was killed, and then they came out of the bedroom basically with guns drawn shooting. So the 2 occupants of the house were killed, and 5 law enforcement officers with HPD were shot, and thankfully none of them passed away, but we did have the 2 people who were the homeowners who got killed. Very sad situation, compounded by the fact that later it was discovered that the officer had indeed lied to obtain the warrant. There was no confidential informant. Later authorities went and talked to all the different confidential informants that this particular officer has worked with. They all denied making the buy. The CI that was named in the warrant denied making the buy ever there, that basically no one had ever bought drugs at this house. Not saying that the people who were in the house were not guilty of some impropriety. I believe that drugs were in fact found there, but certainly not the haul that they were hoping for or looking for. But regardless, it put into a spotlight the issue of not just the fact that, yes, the officer lied, but the whole concept of the no-knock warrant. Well, again, the no-knock warrant allows law enforcement officers to enter property without the immediate prior notification that is typical, such as either ringing a bell or knocking on the door. Law enforcement officers typically, on a regular warrant, whether it's a search warrant or an arrest warrant, will identify themselves, wait a while before any sort of forceful entry is made. With a no-knock warrant, or also called the surprise warrant, the typical scenario is that the law enforcement officers literally seconds before the battering ram hits that door, or possibly even explosive charges to breach that door or that entry portal, only seconds before the warrant being activated and the officers hitting that house, will they announce their presence. It's at that point it's pretty academic. The reason for this is the hope that the officers will try to prevent the destruction of evidence. The fear is that if they're knocking on the front door, well, if there's drugs in the house, the drugs are being burned, they're being flushed down the toilet, etc. Things are being secreted or hidden. And secondly, another main consideration with the no-knock warrant is the risk to officer safety. They fear if the occupants in the house have time to prepare, to gear up, to wake up, arm themselves, possibly put on body armor, etc., that could turn into a shootout. So they are, again, for fear of destruction of evidence and fear of officer safety, the issue of the no-knock warrant has kind of come of age. The requirement for law enforcement officers to announce their presence, it is ancient. It goes back to English common law, literally back to the 1600s. So a very old rule that required law enforcement officers to announce their presence as they were trying to come in and then execute a warrant, whether it be for search or for arrest. Well, in the 1950s, in a case called Miller versus United States, the U.S. Supreme Court recognized that in certain circumstances, the police were allowed to make forced entry into a residence to serve a warrant without the requirement of knocking ahead of time or announcing ahead of time. Also furthered in a case called Wilson versus Arkansas, the Supreme Court recognized the need to prevent the destruction of evidence as possibly being a ground for a no-knock warrant or a surprise warrant. So again, it's not every time. The officers have to usually take extra steps to document to a magistrate judge who is, before they issue the warrant, enunciate, say, specify the reasons why they fear either the destruction of evidence or have a heightened threat to officer safety. I used to work in the district attorney's office in Williamson County and in Polk County, Texas. I have helped author dozens of search warrants, including no-knock warrants. And as a defense attorney, I certainly have had occasion to review search warrants, arrest warrants, including no-knock warrants, looking to make sure all the I's were dotted and the T's were crossed, as it were. So again, with this case here in Texas, down in Houston, recently, that has, again, thrown a spotlight on this whole issue. When should they be used? When can they be used? Again, just sort of a weighing option. One of the discussions here recently has been, with the surprise factor, does that in fact increase the odds of, let's say, a shootout? I mean, we're talking about people generally who have drugs in the house. A lot of times these are narcotic search warrants. People that are known to be drug dealers, yes, they're at risk to be arrested by the police, but they're also at risk to be ripped off by other people, folks that know this is a house that has drugs, that's valuable. This is a house that has guns, that's valuable. This is a house that has money. So if someone's coming in, bursting through the door in the middle of the night, the occupants of that house may or may not know that it's the police versus it's a bunch of bad guys, and so I need to draw my gun and start shooting. In fact, there was a case in 2016 down in Corpus Christi, Texas. A gentleman was acquitted in circumstances very similar to what I just described. A police SWAT came in the door within a no-knock circumstance. The officers made entry. The gentleman, the homeowner, pulls out a gun and starts shooting. He hit 3 SWAT officers. He was charged then with attempted capital murder, and a jury found him not guilty. Said there was not enough proof that the homeowner, the defendant, knew that those were law enforcement officers when he drew his gun and when he started firing. Largely because it was a no-knock warrant, and the people rightfully did not identify themselves until, again, seconds before they breached that house. So again, there is that weighing factor of, is this no-knock warrant, which is intended to surprise the defendant, to give them less time to react, is that actually increasing the odds of something bad happening when that person does not have a chance to say, oops, it's the police, lay down the guns, time to calm down, it's the jig is up, I better stop here. Hard to say. Again, it's law enforcement is an occupation that certainly has a risk. These warrants are never served on people who are generally just without the means to possibly defend themselves and hurt officers. So it is always a risk that needs to be balanced. But again, this case is throwing the spotlight on these other counties' use of the no-knock warrant has caused some re-examination. First, the chief of police in Houston, Texas, Art Acevedo, pretty much immediately came right out and said, you know what, we're not going to use no-knock warrants anymore. He made sort of a blanket statement, and then immediately, within a few days, retracted that statement and said, well, wait a minute. Instead of just saying, we were using them, now we're not going to use them, he basically said, we're going to add another step in the check and balance process. So instead of just an officer in Houston being able to write a warrant and going right to a judge directly, he said, in his words, that that warrant has to start with the officer, and then that warrant, especially a no-knock warrant, has to then be reviewed by, quote, senior command personnel, unquote, before it goes to a judge. So another set of eyes, somebody higher up the command structure, as it were, in Harris County, Texas, would look at the warrant and see, is it backed up? Obviously, is it factual? Does it require a no-knock status, etc., before they even take it to the judge? Also, some other counties have been asked here locally in Texas to sort of clarify their standpoint regarding the use of these no-knock warrants. In Fort Bend County, for example, neighboring Harris County down there in south central Texas, Fort Bend County District Attorney's Office and law enforcement basically said, we don't use no-knock warrants. That's just something we just don't do. We always are going to require our officers to announce their presence. Meanwhile, just north of Houston in Montgomery County, they basically said that their law enforcement has the practice of, instead of the detective going straight to the judge with request for a no-knock warrant, that at all times that detective is going to run it by a supervisor and also consult with the district attorney's office to have an assistant DA go over that warrant before it goes to the judge. In my time in Williamson County, Texas, that was very much the same kind of model that we used during my time there, where a detective would come to a prosecutor, review that warrant first, then the two of them would go downstairs and try to find a judge. Especially if it was a no-knock, the officer better have his or her reasons specified while there is that fear of either destruction of evidence or the fear of heightened danger to the officer that would require the necessity to have this be a no-knock warrant. So again, every county is a little different here in Texas, but this tragedy down there, officers being hurt, homeowners being killed, has brought this to the attention, a sort of rising awareness of how, when, and where these warrants should be used properly or not. And it's caused several counties here recently to sort of revisit their procedures and make sure that things are going to go down smoothly and legally there in their county. Obviously, again, anytime a law enforcement officer would bring completely fictitious information to a magistrate judge asking for a warrant, whether it's a no-knock warrant or a regular search or arrest warrant, that does hurt just the fundamental concepts of checks and balances that we have here in our criminal justice system, not just in Texas, but throughout America. It's all premised on accurate, honesty, truthful information, and when that is undermined, it really hurts everybody. So that's a little highlight of no-knock warrants here in Texas, something that we are re-examining our use of here in a county-by-county basis. As always, this video is being offered for educational and informational purposes only. It's not to be construed as giving exact legal advice and doesn't take place of a true sit-down legal consultation. And unless you're already a contracted client of mine, I'm not your lawyer. Well, this has been Attorney Mark Brunner. If you like what you see, please consider subscribing to this channel, and you'll get notifications as we post more videos on interesting topics here on Texas law. As always, I thank you so much, and I'll see y'all next time.